All right, let's dive into a really fascinating and pivotal U.S. Supreme Court case that has fundamentally reshaped American workplace law, Epic Systems versus Lewis. This case is a perfect storm, sitting right at the intersection of contract law, labor rights, and civil procedure. And believe me, its implications are felt by millions of American workers every single day.
So, here's how we're going to break this down. We'll start with the foundational dispute itself, just to get the facts straight. Subsequently, we'll analyze the employee's argument, which was rooted in the National Labor Relations Act. As well as that, we'll examine the employer's counterargument, which relied on a totally different law, the Federal Arbitration Act. From there, we'll get into the Supreme Court's decision and finally unpack the ruling's incredibly widespread impact.
To begin, let's set the stage. This case wasn't just about one company. It actually brought together several different disputes that all shared one really contentious condition of employment.
At the heart of it all was this requirement. So, an employee, like Jacob Lewis, might believe he was owed unpaid wages under the Fair Labor Standards Act. But to get a job, he had to sign a contract saying he'd handle that dispute one-on-one, through arbitration, not by joining a group lawsuit in a regular court.
And this brings us to the key legal term you have to understand: mandatory individual arbitration. It's a clause in a contract that basically says you agree to give up your right to team up with your coworkers in a class action lawsuit. The entire case really hinged on one question: is that waiver legally enforceable?
Let's now turn to how the employees challenged this. Their argument wasn't really about contract law. Instead, it was based on a bedrock piece of American labor law. This phrase right here, from the National Labor Relations Act, or NLRA, was everything for the employees' side. They argued that banding together to sue your employer is a perfect modern example of a concerted activity for mutual aid or protection.
So you can see their legal argument followed a very clear, logical path. First, they established that a class action lawsuit is a protected, concerted activity. Therefore, they reasoned, any contract that forces an employee to waive this right contains an illegal term under the NLRA. Furthermore, they pointed to the Federal Arbitration Act's own saving clause, which says you can invalidate an arbitration agreement for any reason you could invalidate a regular contract. And for them, this illegality was exactly that kind of reason.
Okay, now let's flip the coin and look at the counterargument. We're going to explore the employer's rebuttal, which leaned on a different and you could say equally powerful federal law. And this slide really nails the core conflict. On one side, you have the NLRA's broad protection of workers acting together. Conversely, you have the Federal Arbitration Act, or FAA, which has a very clear, very strong command: courts must enforce arbitration agreements just as they are written. Consequently, the Supreme Court was faced with a classic statutory showdown. When these two laws clash, which one wins?
The employer's position was incredibly direct. They argued that the FAA's command is specific and totally unambiguous. It tells courts to enforce arbitration agreements by their terms. In addition to this, they argued the class action waiver was simply one of those terms, and because of that, it had to be enforced.
So with these two major federal laws seemingly at odds, the critical question landed squarely with the Supreme Court. How do you resolve this tension?
And the court's decision, when it was handed down in May of 2018, was exceptionally close. A 5-4 vote. That really underscores just how contentious this was, how deeply divided the legal community was on how to interpret these laws. So the crucial point of the majority's reasoning came down to a classic principle of statutory interpretation. Justice Gorsuch, writing for the majority, said that while the NLRA protects concerted activities generally, it never explicitly says there's a right to a class action lawsuit. Whereas the FAA's command to enforce arbitration agreements as written is incredibly specific. The court basically applied an old legal rule. The specific statute governs the general one. And here, they found the FAA's specific directive had to take precedent. So the ultimate holding was unambiguous. The Supreme Court ruled that the Federal Arbitration Act means what it says. Courts are required to enforce individual arbitration agreements, and that includes the waivers of class and collective actions according to their terms. Period.
Now, in spite of all that highly technical legal reasoning, the practical consequences of this decision for the American workplace have been absolutely enormous. So let's explore that real-world aftermath.
And the sheer scale of the impact is just staggering. It's estimated that 60 million non-union American workers are covered by these clauses. For this huge slice of the workforce, the main path for challenging systemic workplace problems was effectively shut down.
The decision really led to several key consequences. For employers, it was a huge win. It gave them a powerful protective shield against expensive class action suits. For employees, however, Going after systemic problems like widespread wage theft or discrimination became much, much harder. Moreover, this created a really critical economic problem for individual workers.
And this brings us to this crucial legal concept called negative value claims. Think about it this way. Say your employer owes you a few $100s in unpaid overtime. The cost of hiring a lawyer and paying for arbitration would easily be more than what you could ever hope to get back. Class actions solve that problem. They bundle thousands of these small claims together into one big case that makes economic sense. By taking that option off the table, the EPIC system's ruling basically means that many smaller violations of employment law might just go unchallenged.
And this all leaves us with a final, really thought-provoking question that goes right to the heart of the separation of powers in the U.S. system. When two federal laws seem to be in conflict, as the NLRA and FAA were here, who should have the final say on which one prevails? Should it be the courts interpreting the laws, or the legislature who wrote them in the first place? The EPIC system's case gives us one answer from the court, but the fundamental debate over that question is far from over.